an appropriation to herself of very nearly 1/3 of our whole republic. My government and people feel that in President Cleveland, they have a friend and protector. Despite the efforts of President Cleveland and his administration, the British remained opposed to arbitration with Venezuela, leading Venezuela to break diplomatic relations. In December 1894, with the territorial dispute continuing to fester, Venezuela's minister in Washington, Jose Andrade, a name you will hear frequently in this presentation, wrote to the U.S. Secretary of State, citing the threat of further British expansion and urging the United States once again to intervene on Venezuela's behalf. As Your Excellency will understand, the dispute already has a phase that we would call threatening, given that the colonial authorities are preparing to expand their jurisdiction even further, and to thus enter into regions where the Republic has established regular centers. In view of this, my government reiterates to the United States government its request for effective and direct intervention, which our Minister Plenipotentiary presented to the Department of State in Washington some time ago and has continually ratified. Within days, President Cleveland responded in an address to the U.S. Congress. I shall renew the efforts heretofore made to bring about a restoration of diplomatic relations between the disputants and to induce a reference to arbitration, a resort to which Great Britain so conspicuously favors in principle and respects in practice, and which is earnestly sought by her weaker adversary. When the British continued to resist President Cleveland's demand for arbitration, the U.S. applied greater pressure. In July 1895, the new U.S. Secretary of State, Richard Olney, another name that features prominently in the narrative, instructed the U.S. mission in London to convey the following admonition to the British authorities. The duty of the President appears to him unmistakable and imperative. Great Britain's assertion of title to the disputed territory, combined with her refusal to have that title investigated, being a substantial appropriation of the territory to her own use, not to protest and give warning that the transaction will be regarded as injurious to the people of the United States, as well as oppressive in itself, would be to ignore an established policy with which the honor and welfare of this country are closely identified. When the British ignored this warning, President Cleveland took matters into his own hands. In his December 1895 address to the U.S. Congress, he expressly invoked the Monroe Doctrine against the expansion of British Guyana, warning the British that, quote, its enforcement is important to our peace and safety as a nation and is essential to the integrity of our free institutions and the tranquil maintenance of our distinctive form of government. Sentiments in the United States, including at its highest levels of government, ran so strongly in favor of Venezuela and against Great Britain that, as Venezuela's foreign minister told the UN General Assembly in 1962, quote, the United States was on the verge of going to war with Great Britain. In this extremely grave situation, that's how Venezuela described it, President Cleveland, with the full support of the US Congress, went beyond words to concrete action. He announced the creation of a new presidential commission of experts, headed by a US Supreme Court Justice, David Brewer, to investigate and report on the true boundary between Venezuela and British Guyana, which the US would then seek to enforce. As President Cleveland explained, when such report is made and accepted, it will, in my opinion, be the duty of the United States to resist by every means in its power, as willful aggression upon its rights and interests, the appropriation by Great Britain of any lands or the exercise of governmental jurisdiction over any territory, after which investigation we have determined a right belongs to Venezuela. This measure, with its implicit suggestion of military intervention by the US, finally broke Britain's resistance to arbitration of the dispute. In its written pleadings, Venezuela acknowledges this. If the British finally accepted to enter into an arbitration process, it was under US pressure, and to ward off the risk of seeing the work of the Venezuela Boundary Commission concluding, as it had to, that the true boundary had always been the one claimed by Venezuela. As Venezuela further acknowledged in its counter-memorial, it is a fact that Venezuela requested the protection of the United States in order to resist Great Britain's conduct and reach a peaceful solution to the territorial dispute. It was clear that the possibility of submitting the dispute to arbitration could have materialized only with the support of the United States. And Venezuela continued. Great Britain accepted arbitration only because of the pressure put on it by the United States. Neither this conclusion nor the antecedent events that led up to it can legitimately be disputed by Venezuela at this stage of the proceedings, nor can the fundamental features of the ensuing negotiations that led to the 1897 treaty. In particular, it is beyond dispute that the negotiations were conducted until the final stage directly between U.S. Secretary of State Richard Olney and the British ambassador in Washington, Lord Julian Pauncefote. It is uncontested that Venezuela appointed a team of 2 representatives, Jose Andrade, its minister in Washington, and James Storrow, an American attorney who had represented Venezuela before President Cleveland's Boundary Commission, to liaise and engage directly with Secretary Olney and assure that Venezuela's interests were reflected in the treaty negotiations. It is also undisputed that the negotiation of the treaty took place between January and November 1896, that a draft agreement was presented to the Venezuelan government in November 1896, that further negotiations took place directly between Venezuela and Great Britain thereafter, and that Venezuela then authorized Mr. Andrade as minister plenipotentiary to sign it, which he did in Washington on 2 February 1897. Later that month, on 20 February, the president of Venezuela, General Joaquin Crespo, submitted the treaty to the Venezuelan Congress with a message calling for its ratification. In so doing, the Venezuelan president expressed gratitude to the United States for the part it played in negotiating the treaty. It is eminently just to acknowledge that the great republic endeavored persistently to direct the matter by the most favorable route, and that the outcome achieved represents an effort of intelligence and will worthy of praise and gratitude from those of us who are familiar with the intricate details of this very complicated matter. The treaty was then ratified by the Venezuelan Congress by legislative decree on 17 April 1897. The final page of this decree is at tab 5.1 of your folders. None of these facts, none of them, are or can legitimately be disputed. I turn to part 2 and Venezuela's main challenge to the validity of the 1897 treaty. This is its contention that it was excluded from the treaty negotiations and that the treaty was, in its words, negotiated by the US and Great Britain, quote, behind Venezuela's back, in collusion with one another to further Britain's interests at Venezuela's expense, with the result that, to cite Venezuela's written pleadings, the treaty was, quote, prejudicial to the interests and dignity of Venezuela in respect of crucial issues. Venezuela argues in particular that as a result of this purported British and American conspiracy, its views on two issues that it considered most critical, concerning the acquisition of title by prescription and respect for the 1850 agreement between Venezuela and Great Britain, were not taken into account or reflected in the treaty. The argument is that this purported Anglo-American cabal not only prejudiced its interests, but constituted a fraud on Venezuela within the meaning of Article 49 of the Vienna Convention on the Law of Treaties, sufficient to invalidate the treaty. On the same allegations, Venezuela argues that it ratified the 1897 treaty in error, as defined by Article 48 of the Vienna Convention, on the mistaken understanding that the treaty text negotiated on its behalf by the United States had protected its vital interests, only to find out during the arbitration 2 years later that it did not. Mr. President, neither Venezuela's contention of fraud nor its contention of error withstands scrutiny or is even plausible. In the first place, its contentions are counterintuitive. They strain credulity, requiring you to conclude that the United States, which between 1883 and 1896 had consistently supported Venezuela in opposing British colonial expansion and demanding that Britain accede to arbitration of the territorial dispute, made a complete volte-face when negotiation of the arbitration agreement began, by switching sides and supporting Britain's interests in the disputed territory to the prejudice of Venezuela's. For Venezuela, this would be a hard sell in any case, let alone a case in which it expressly agrees, as you have seen, that but for the full support of the United States and the pressure it applied to Great Britain, including the threat of US military intervention, the British would never have agreed to arbitration and would have continued to strengthen their hold on the disputed territory in the face of Venezuela's incapacity to stop them. But beyond its illogic, Venezuela's argument is also counterfactual, completely so. It is thoroughly contradicted by the contemporaneous documentary evidence of the treaty negotiation process that is part of the record in this case. I will take you to the key documents presently. The arbitration agreement was largely negotiated directly by the British ambassador to the United States, Lord Pauncefort, and the US Secretary of State, Richard Olney, on behalf of Venezuela. At the time, there was no objection by Venezuela. There is no evidence of any kind of such an objection. To the contrary, the evidence shows that Venezuela trusted Mr. Olney, as well as his boss, President Cleveland, to protect its interests. And it believed Secretary Olney would have more influence with the British than its own representatives. This is confirmed by what Venezuela's Ministry of Foreign Affairs reported contemporaneously in August 1896 upon reviewing the correspondence between the US and Great Britain in the negotiation process. The correspondence once again highlights the positive role of the Great Republic of the North in an issue of paramount interest to the entire hemisphere, due to its close connection with the integrity of the territories constituted as free and sovereign nations. Furthermore, having been considered by the President of the Republic and the Council of Ministers, the nature of this publication, expertly and wisely defended by the Department of State in Washington, and setting out the principles and doctrines to which Venezuela adheres in order to uphold its rights and dignity in one of the gravest issues recorded in its political annals, has led to the decision to produce a special edition in Spanish of all the notes comprising the above-mentioned correspondence, as both a pledge of recognition to the government of the United States and a welcome contribution to the promotion of principles so gallantly supported by the great people of the North in support of common security and international peace. This contemporaneous Venezuelan assessment of the role played by the U.S. demonstrates that Venezuela was manifestly content with the way Secretary of State Olney handled the treaty negotiations to that point. Venezuela thus focuses on a later stage of the negotiations between September and November 1896, during which the subjects about which it expresses most concern, the acquisition of title by prescription and preservation of the 1850 agreement, were directly addressed by Secretary of State Olney and Lord Poncefic. Venezuela's principal contention now, as opposed to what it said contemporaneously, is that during this stage of the negotiations, the two representatives of Venezuela, Messrs. Andrade and Storo, were kept in the dark by Secretary of State Olney and denied the opportunity to defend or even explain Venezuela's interests. This is entirely fallacious. It is completely refuted by the documentary evidence, as you will now see. Far from keeping Venezuela's representatives at arm's length, on 12 September 1896, Secretary of State Olney sent Mr. Storo an early draft of the clause on prescription, indicating he would come to meet Mr. Storo at Mr. Storo's home in the evening, prior to a meeting with Lord Poncefic the following day. On your screens is a copy of Mr. Olney's message to Mr. Storo and the enclosed treaty text on prescription. You will note the highlighted portion of the text showing a proposed prescription period of 40 years, explaining that any of the disputed territory which had been under the actual, exclusive, and continuous dominion and control of one of the parties for that period would be held to form part of the territory of that party. Mr. Storo wrote back to Mr. Olney on 17 September 1896. Referring to their recent meeting at his home, he said, "Our views agreed the other day, so that I thought it enough to answer your telegram, no change." Mr. Storo continued, however, by advocating for a longer period of prescription than the 40-year period initially presented by Mr. Olney. Settlements by British subjects living under British rule in territory administered solely by British rule, if long continued, will certainly, I think, give title. 60 years is the classic period. I would agree to less as a rule rather than lose an arbitration. Further down the page, Mr. Storo also highlighted the importance to Venezuela of the 1850 agreement. I do not think that the truce of 1850 could be waived or impaired, or that it ought to be. The evidence shows that far from ignoring them, Mr. Olney received Mr. Storo's proposals, acted upon them, and incorporated them into his own proposal to Lord Poncefic, and he succeeded in achieving them. This is apparent from the next set of documents from October 1896, which comprise the written communications between Mr. Storo and Mr. Olney, and between Mr. Olney and Lord Poncefic. On these issues, prescription and the 1850 agreement, they show unmistakably that Venezuela's views were fully taken into account and advanced by Mr. Olney in his negotiations with Lord Pauncefort, and Venezuela's objectives were achieved. On the 26th of October, for example, Mr. Storrow sent Mr. Olney a revised draft of the prescription clause, accompanied by a handwritten note. It states, in reference to the number of years required for prescription to take effect, filling in the blanks with 60, I see no objection to the actual occupation part. Mr. Storrow's note continues. I will try to write a couple of sentences more and send these to your house in the afternoon. And Mr. Storrow did just that. Here is the text he sent to Mr. Olney that afternoon. The arbitrators shall adjudge a title by prescription or adverse occupation to be a good title, and shall consider 60 years as a sufficient period to establish a title by prescription. But the arbitrators may and shall, the next word is illegible, and apply all the rules of law and fact appropriate to this case, as far as they do not contravene the foregoing provision. The British position was that the prescription period should be no more than 30 years, which would have facilitated their claim of title to any of the disputed territory that they had consistently occupied since as late as 1867, 30 years before the treaty then under negotiation would enter into effect. The British proposal can be found in Venezuela's counter memorial at Annex 169. Mr. Storrow sent another note to Mr. Olney on 28 October, 1896. And again, it shows the intimacy of the relationship between Venezuela's representatives and the U.S. Secretary of State. Mr. Andrade and I will come to your house at 8:15 tonight unless we hear to the contrary. The date of this meeting was propitious because the following day, 29 October, after consulting with Venezuela's two representatives the previous evening, Mr. Olney sent to Lord Pauncefort a new draft of the treaty. In respect of prescription, Mr. Olney wrote, I cannot recede from my original suggestion as to a conventional term of prescription further than to consent to 50 years being substituted for 60. Mr. Olney explained to Lord Pauncefort that he could not agree to a shorter term than 50 years because anything less might undermine the force of the 1850 agreement, by which the parties had pledged to forego further expansion into the disputed territory. A 50-year prescription rate would preserve the 1850 agreement because it would disregard any occupation of the disputed territory that commenced after 1847, assuming again that the treaty would enter into force in 1897. By contrast, the 30-year prescription period proposed by the British, or even a 40-year period, would have conferred title on any continuous occupation commenced by 1857. And that, of course, would contravene the 1850 agreement, which is why Mr. Olney would not agree to that. As Mr. Olney explained, if a shorter term be stipulated, it is certain to be urged, and with great force, that the agreement of 1850 is thereby waived, at least pro tanto. The documentary evidence thus shows Mr. Olney's firm advocacy of Venezuela's positions on both the prescription period and on the 1850 agreement. Now, earlier in that letter, Mr. Olney explained to Lord Pauncefort that with a 50-year prescription period, there would be no need for the arbitration agreement to include an express reference to the 1850 agreement, because the 50-year prescription period would accomplish the same result, precluding recognition of any occupation of the disputed territory that commenced after 1850. In fact, the 1850 agreement had a major gap. a major lacuna, as our agent told you earlier this morning, consisting of an exchange of letters between Great Britain and Venezuela in which they each abjured any further expansion into disputed territory. They conspicuously failed to identify what or where the disputed territory was, leaving this critical term open to interpretation. Hence, Mr. Olney wrote to Lord Pauncefort, an attempt to construe it will involve us in protracted debate and indefinitely postpone the attainment of the object we now have in view. The agreement, that's the 1850 agreement, will come and should come before the arbitral tribunal in the natural course and will be interpreted by that tribunal by the aid of facts, documents, and considerations of which we cannot now know anything. On 30 October, Lord Pauncefort reported to his Prime Minister, Lord Salisbury, on his exchanges with Mr. Olney on these subjects. Quote, I have tried in vain every argument and put the greatest pressure on him to obtain a further reduction, that is in the prescription period. He, that is Olney, says he cannot consent in justice to Venezuela. He contends that a limit of 30 or even 40 years would nullify the agreement of 1850, to which the arbitrators must be left to give such effect as they think right, and that 50 years is the lowest period of prescription suggested by jurists and does not preclude or affect claims to the territory based on any other title. It bears emphasis that what this evidence shows is that far from turning his back on Venezuela's representatives or concluding with the British to protect their interests rather than Venezuela's, the U.S. Secretary of State did exactly the opposite of what Venezuela has pleaded in this case. As these contemporaneous documents demonstrate, Mr. Olney took Venezuela's representatives directly into his confidence, shared drafts of the treaty text with them, received their proposals on the key issues with which Venezuela was concerned, incorporated them into his exchanges with Lord Pauncefort, refused to concede any ground, in spite of what Lord Pauncefort called every argument and the greatest pressure, and ultimately he delivered what Venezuela's representatives had requested: a prolonged period of prescription of 50 years and preservation of the 1850 agreement. The terms of the draft treaty were in fact agreed with the approval of Venezuela's two representatives. This is what Mr. Olney reported to Justice Brewer, then the chairman of President Cleveland's Venezuela Boundary Commission, on 10 November 1896, shortly after the conclusion of his exchanges with Lord Pauncefort. The United States and Great Britain are in entire accord as to the provisions of a proposed treaty between Great Britain and Venezuela. The treaty is so eminently just and fair as respects both parties, so thoroughly protects the rights and claims of Venezuela, that I cannot conceive of it not being approved by the Venezuelan president and Congress. It is thoroughly approved by the Council of Venezuela here and by the Venezuelan minister at this capital, referring to Mr. Storrow and Minister Andrade. Mr. President, the evidence you have now seen from the contemporaneous documentary record thoroughly defeats Venezuela's challenge to the 1897 treaty, that it was somehow negotiated behind Venezuela's back without involvement of its representatives and failed to take account of its interests. There is absolutely nothing in this record to contradict Mr. Olney's statement that the treaty he negotiated with Lord Pauncefort was, quote, thoroughly approved by the Council of Venezuela and by the Venezuelan minister in this capital. Mr. Olney's sense that the treaty would be approved by the President and Congress of Venezuela also proved to be spot on, as you will now see. At the very time of Mr. Olney's letter to Justice Brewer, Mr. Storrow and Mr. Andrade were en route to Caracas to obtain the Venezuela government's approval of the draft treaty. On 29 November, Mr. Storrow sent Mr. Olney a detailed report of their meetings with the president, the foreign minister, other government officials, and a commission of experts the government had established to analyze the treaty. Because of the report's length, 9 pages, I will show you now only the most important parts, but I think you will find it helpful to read it in its entirety, and for that reason, we have included it at tab 5.2 of your folders. At page 2, the report describes the reactions of the Venezuelan president and other senior officials with whom Mr. Storrow and Mr. Andrade had met. This is Mr. Storrow writing. Mr. Andrade afterwards had a long talk with him, the president, and afterward with the Minister of Foreign Affairs and Dr. Brunal Arra, Minister of the Treasury, the strongest man in the cabinet. They were all satisfied with the treaty and said there should not be a moment's hesitation about adopting it. I have myself seen Dr. Brunal and Dr. Rojas, that's the Minister of Foreign Affairs, the latter quite frequently, and they are entirely clear on the subject. Page 4, the report describes the meeting Mr. Storrow and Mr. Andrade had with the commission of experts appointed to analyze the treaty and their discussion on the subject of prescription. One of the experts, Dr. Sejas, opposed on constitutional grounds any recognition by Venezuela of prescription as a source of title to territory. He was the only commission member to take this view. However, quote, Dr. Sejas finally admitted that he had no doubt prescription applied and that the arbitrators would apply it, but that to admit it in terms of the treaty would be to violate the rule of the Constitution against cessions of territory. Mr. Storrow and Mr. Andrade responded. We said it was not a concession. Prescription was, I thought, our strongest ground, and I wanted GB to agree to it, and of all possible terms, 50 years was the best for us. A week later, on 7 December, Mr. Andrade sent a telegram to Mr. Olney in which he reported this. Memorandum accepted. Will be published here Monday afternoon. Extra session of Congress will be called as soon as possible. Am authorized to sign the treaty with small exceptions, such as provisions filling vacancies in the case of death or disability. But Venezuela expect by treaty or by diplomatic correspondence through you agreement to prevent aggressive or unfriendly acts near line of contact, and also no new mine concessions shall be granted. 2 days later, Dr. Rojas, the foreign minister, wrote to Mr. Andrade, indicating Venezuela's desire for other changes to the treaty, 2 of which he regarded as particularly important. One involved the appointment of arbitrators, which I will discuss in part 3 of my presentation. The other concerned prescription. Dr. Rojas was content with prescription as a source of title to territory, noting that, quote, Venezuela has declared itself in favor of this system. He was also content with the 50-year prescription period already included in the draft treaty. But he wanted to add to the treaty a clause requiring application of the principles of international law to territorial claims based on prescription. He proposed that the following text be inserted into the treaty. The adverse possession for 50 years referred to in Rule A must be in accordance with the principles of international law, possession in the name of the state and in the capacity of owner, public, continuous, uninterrupted, and peaceful. Dr. Rojas's letter is particularly significant because it directly and fully contradicts Venezuela's argument in the rejoinder that they were opposed to prescription as a source of title, and that Mr. Olney betrayed them and even defrauded them by agreeing with the British on a 50-year prescription rule. That argument is entirely false. At the conclusion of his letter, Dr. Rojas gave this instruction to Mr. Andrade. If, despite the efforts that are urged upon you to make, any of the stated modifications should be rejected in terms that may clear the impossibility of their acceptance, you may dispense with it in the course of the negotiations and even sign the document without the need for new consultation with this office. So determined was Venezuela to get this treaty signed. Mr. Andrade communicated Dr. Rojas's proposal to Mr. Olney in a telegram sent the following day on 10 December. Later that month, on 28 December, after he returned to Washington, he met with Mr. Olney at his home to discuss the proposals. After the meeting, Mr. Andrade wrote this to Dr. Rojas in Caracas. Mr. Olney found all the conditions commendable, save the one regarding prescription, about which he expressed some discouragement that he deemed it superfluous, believing such an interpretation as that is one that is inconsistent with international law, to be neither possible or likely, and that without need, it would give occasion for Great Britain to delay us with a discussion lasting months or perhaps years from which no benefit would ultimately result. Mr. Andrade, to whom Venezuela granted full powers to sign the treaty, then described how he responded to Mr. Olney. I hinted that if such were his view, I would not insist upon submitting the aforementioned clarification to the British ambassador. And with a nod unmistakable in its meaning, he approved of such disposition. To conclude part two of this presentation, it is crystal clear that Venezuela has no legal or evidential basis, none whatsoever, to argue that the 1897 treaty is invalid on grounds that the United States failed to consult with Venezuela during negotiation of the treaty, or that it colluded with Britain behind Venezuela's back, or that it accepted terms that favored British interest to the prejudice of those of Venezuela. The evidence makes clear that the United States did not contravene Venezuela's position on prescription, which was duly reflected in the treaty's final text, or on the continuing validity of the 1850 agreement. In both cases, the United States considered that it had fully protected Venezuela's interest, and the contemporaneous documentary evidence shows that Venezuela agreed that it had done so. I turn to part three, which I can cover much more quickly. In its written pleadings, Venezuela challenges the validity of the 1897 treaty on the ground that without its consent, the treaty excluded the appointment of any Venezuelan arbitrators. This, too, is a groundless argument, again, completely defeated by the contemporaneous evidence. The draft treaty delivered to Caracas in November 1896 addressed the appointment of arbitrators in Article 2. It provided for a tribunal of 5 members, 2 to be nominated by the judges of the Supreme Court of the United States, 2 to be nominated by the British High Court of Justice, and the 5th to be appointed by the 4 so nominated. This left open the possibility that a Venezuelan could be appointed to the tribunal by the U.S. justices, a possibility of which the British were quite aware and quite uncomfortable. On 8 December 1896, Lord Ponsford wrote to his prime minister that he was a little uneasy whether the U.S. judges may not be urged by Mr. Olney to appoint a Venezuelan as arbitrator because, quote, we know of no Venezuelan jurist worthy of the name or whom we could consent to entrust with the function of arbitrator in such a case. This statement is certainly offensive to us as well as to Venezuela. We call attention to it only to underscore the adamance of Britain's stance on the clause regarding appointment of arbitrators. Understandably, Venezuela bristled at Lord Ponsford's dismissive view of its desire to appoint one of its nationals to the arbitral tribunal. On 10 December, Venezuela's representative, Mr. Storrow, cabled Mr. Olney from Caracas that, quote, treaty stands accepted as cabled, but there are sharp attacks about the appointment of arbitrators and cabinet very desirous have one Venezuelan on the tribunal. This would help much with public and Congress. Mr. Olney duly transmitted Mr. Storrow's message to Lord Ponsford the next day. The day after that, on 12 December, Lord Ponsford responded to Mr. Olney, rejecting Venezuela's request. In his words, quote, it would be a most dangerous departure from the long-established practice of international arbitration. The very reason for taking the nomination of the arbitrators on the side of Venezuela out of the hands of the Venezuelan government and confiding that duty to two judges of the Supreme Court was that the latter should appoint arbitrators of U.S. nationality. Faced with this British rejection, Mr. Olney sent a telegram to Mr. Storrow informing him that matter closed between Great Britain and the United States. Changes treaty must be made between Great Britain and Venezuela. And that is precisely what happened. On 28 December, Mr. Andrade, having returned to Washington from Caracas, met first with Mr. Olney and then directly with Lord Ponsford. And they reached an agreement on the appointment of arbitrators, an agreement reached by Mr. Andrade with Lord Ponsford, his British counterpart. As recorded in Mr. Andrade's report to Dr. Rojas of 9 January 1897, he, Mr. Andrade, and Lord Ponsford agreed that Article 2 of the treaty would be revised to attribute to Venezuela the appointment of only one of the arbitrators on her side and the other to the United States, it being noted that the Venezuelan appointee would be a judge from the Supreme Court of this country, the United States. Mr. Andrade added that he considered this agreement beneficial to Venezuela. The more I think of it, the more I think that Venezuela, far from wishing to restrict the participation of the United States in the composition of the tribunal, should seek to augment it. The Venezuelan government agreed to the arrangement negotiated by Mr. Andrade and Lord Ponsford, and it decided to exercise its right of appointment by nominating the Chief Justice of the U.S. Supreme Court, Melville Fuller. This meant that Venezuela would be represented on the tribunal by two U.S. Supreme Court justices, since it had already been decided that the other representative would be Justice David Brewer, the same Justice David Brewer who was serving as the chairman of President Cleveland's Venezuela Boundary Commission. Mr. Storrow, Venezuela's counsel, considered that this solution gave Venezuela exactly what it wanted. On 26 January, he wrote to Foreign Minister Rojas, quote, I think you have got what you desired, a clear and formal appointing power of Venezuela on the face of the treaty, precisely the same two jurors whom at Caracas you told me you preferred. President Crespo also regarded this as a win for Venezuela. In his address of 20 February 1897, he emphasized, quote, the government deemed it indispensable to introduce into the treaty a modification aimed at ensuring the appointment of the arbitral tribunal with the effective participation of the Venezuelan authorities. This proposal was promptly submitted and the arbitration was accepted. Plainly, there was no fraud or error in regard to the agreement on appointment of the arbitrators. Venezuela was fully informed of the draft treaty text, the subsequent exchanges between Mr. Olney and Lord Ponsford, and the necessity of direct negotiations between Venezuela and Great Britain to resolve the issue. And those negotiations resulted in an agreement with which Venezuela professed its satisfaction. These indisputable facts doom Venezuela's challenge to the validity of the 1897 treaty based on the appointment of arbitrators. I come to part 4, the final part of my presentation concerning, and this concerns Venezuela's claim that it agreed to the 1897 treaty under coercion, as prohibited by Article 52 of the 1969 Vienna Convention. It will take me even less time to dispense with this argument. In the first place, Article 52 of the 1969 Convention has no retroactive application. As the ILC commented, quote, "The Commission considered that there is no question of the article having retroactive effects on the validity of treaties concluded prior to the establishment of the modern law." In 1897, customary international law did not recognize coercion as a basis for invalidating a treaty. For the legal discussion, I refer the court to Guyana's reply at paragraphs 2.102 to 2.110. But even if there were such a rule in 1897 quad non, what coercion is Venezuela talking about? How was it coerced into signing the 1897 treaty, and by whom? There is absolutely no evidence that Mr. Olney or President Cleveland or the United States coerced Venezuela in any way. The evidence is all to the contrary, particularly as Mr. Olney wrote to Justice Brewer. Both of Venezuela's representatives, Mr. Andrade and Mr. Storrow, were fully satisfied with the draft treaty that had been negotiated. In February 1897, in submitting the treaty to the Venezuelan Congress for ratification, President Crespo himself made clear that Venezuela was not coerced into signing the treaty. These are his words. "The settlement plan was presented to Venezuela for its consideration with no coercive intent and in full respect of the sovereignty and independence of the Republic." How can they say they were coerced? The official yearbook published by Venezuela's foreign ministry for 1897 declared that the final terms of the treaty demonstrated that, quote, "The government has neither paused nor spared any effort in the task of safeguarding the territorial integrity of the Republic." And it included this statement by the foreign minister expressing gratitude to the United States for its support in the treaty negotiations. Allow me to express my conviction that the foundations of this treaty represent, on the part of the United States, a noble and eminent effort for the sake of continental peace. These terms alone will serve as an enduring reminder for Venezuela of the interest with which its powerful sister nation sought to reconcile it with the great British nation in a dispute lasting more than half a century, marked by bitter incidents and perilous situations. Faced with this contemporaneous documentary evidence, how can Venezuela, in the present case, possibly argue that it was coerced to accept the treaty? In fact, it fails to identify any acts of coercion against it or any persons or entities who might have perpetrated such acts. Instead, it complains of what it calls, quote, "structural coercion." In Venezuela's telling, it found itself in a situation in which it had no choice but to accept arbitration of its territorial dispute with Great Britain, because the alternative would have been to subject itself to further British expansion, which it was powerless to stop. But in making this argument, Venezuela conveniently forgets or deliberately ignores the fact that it had been pleading for precisely this outcome, an arbitration agreement with Great Britain, for the better part of 2 decades, that it repeatedly beseeched the United States to come to its assistance and to press the British to accept arbitration of the territorial dispute. That under U.S. pressure, the British finally agreed, and that the treaty negotiated by the U.S. in close consultation with Venezuela's representatives was deemed by Venezuela to be acceptable and worthy of signature. Venezuela's very belated contention, 66 years after the fact, that it was coerced into signing the treaty, physically or structurally, has no factual support. It is completely contradicted by the evidence before you. The bottom line, Mr. President, is that Venezuela cannot come up with any basis, any legitimate basis whatsoever, for invalidating the 1897 treaty, or for invalidating the 1899 arbitral award on the basis of an allegedly invalid compromis. This afternoon, my colleagues will demonstrate convincingly that there are no other bases for invalidating the 1899 award or the international boundary that resulted from it, and that the award was and remains valid and binding on both Venezuela and Guyana. Mr. President, members of the court, I thank you for your kind courtesy and patient attention. This concludes Guyana's submissions in this session. We wish you a pleasant lunch, and we look forward to resuming our submissions this afternoon.
I thank Mr. Reckler. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. The sitting is closed.
One Love. Advertise with us, and let's help you promote your next product, project, or event. More than 1 million viewers every month in Guyana and all over the globe. No project too big, no project too small. Delta 9 Media. Let's help your project reach its widest possible audience.